Hello everyone, I'll be discussing Republic Act number 9165, the Comprehensive Dangerous Drugs Act of 2002. So this is in relation to crimes against public interest. So Republic Act 9165 mandates the government to pursue an intensive and unrelenting campaign against the trafficking and use of dangerous drugs and other similar substances. So there are actually many unlawful acts under this special act. And according to the unlawful acts, there are punishment pertaining to it. So what are the unlawful acts under RA 9165? So we have the importation of dangerous drugs and or controlled precursors and essential chemicals, the sale, trading, administration, dispensation, delivery, distribution, and transportation of dangerous drugs and or controlled precursors and essential chemicals, the maintenance of a den, dive, or resort, employees and visitors of a den, dive, or resort, manufacturer of drugs and or controlled precursors and essential chemicals, illegal chemical diversion of controlled precursors and essential chemicals, manufacture or delivery of equipment, instrument, apparatus, and other paraphernalia for dangerous drugs and or controlled precursors and essential chemicals, possession of dangerous drugs, possession of equipment, instrument, apparatus, and other paraphernalia for dangerous drugs, possession of dangerous drugs during parties, social gathering, or meetings, possession of equipment, instrument, apparatus, and other paraphernalia for dangerous drugs during parties, social gatherings, or meetings, use of dangerous drugs, and cultivation of culture of plants classified as dangerous drugs or sources thereof. So the punishment for these unlawful acts are provided in the RA 9165 Official Gazette, or it can be viewed also in the Lawfil. So the PDEA shall take charge and have custody of all dangerous drugs, plant sources of dangerous drugs, controlled precursors and essential chemicals, as well as instruments or paraphernalia and or laboratory equipment so confiscated, seized, and or surrendered for proper disposition. So in order to fully understand RA 9165, let's discuss the case of People of the Philippines versus Josel Banares de Dios. This was decided in January 22, 2020. So the issue here is whether or not Josel Banares is guilty under Sections 5 and 11, Article 2 of RA 9165, Comprehensive Dangerous Drugs Act. So the facts of the case are as follows. So this case stemmed from two informations filed before the Regional Trial Court charging Josel Banares of illegal sale and illegal possession of dangerous drugs respectively. On June 5, 2014, members of the Tabaco City Police Station, together with the confidential informant, successfully implemented a buy-bust operation against Josel Banares, during which one heat-sealed plastic sachet containing 0.024 gram of white crystalline substance was recovered from him. Upon further research, the police officer was able to seize a pouch containing two more heat-sealed plastic sachets of suspected shabu from Josel Banares. Immediately thereafter, the police officer conducted the marking, inventory, and photography of the seized items in the presence of Media Representative Brutamonte, Department of Justice Representative Barbacena, Barangay Official Gascon, and accused appellant at the place of apprehension. The seized items were then brought to the crime laboratory, where after examination tested positive for methamphetamine hydrochloride, also known as shabu, which is a dangerous drug. So Josel Banares denied the charges against him, and the Regional Trial Court found accused appellant guilty beyond reasonable doubt for violations of Section 5 and 11, Article 2 of RA 9165, which is the sale and possession of illegal drugs. CA affirmed in toto the trial court ruling. It found that the prosecution was able to successfully establish all the elements necessary to convict Banares of the crimes charged. Hence, this appeal seeking that Banares' conviction be overturned. So the Supreme Court held that Banares is guilty under Republic Act 9165 because all the elements for illegal sale of dangerous drugs act and possession of dangerous drugs act are present. So, the elements of illegal sale of dangerous drugs under Section 5, Article 2 of RA 9165 are as follows. So, the identity of the buyer and the seller, the object, and the consideration, which is present actually in this case because the courts correctly found that Banares committed the crime of illegal sale of dangerous drugs, as the records clearly show that he was caught in flagrante delicto selling shabu to the poster buyer Police Officer 3 Kodia during a legitimate buy-bust operation conducted by the members of the Tabaco City Police Station. And the second element is also present, the delivery of the things sold and the payment. So Banares here delivered and sold the shabu to Police Officer 3 Kodia. As for the elements of illegal possession of dangerous drugs under Section 11, Article 2 of RA 9165, which are all present, the first element, the accused was in possession of an item or object identified as dangerous or prohibited drug, is present because courts correctly ruled that Banares committed the crime of illegal possession of dangerous drugs as he possessed plastic sachets containing shabu when he was arrested. The element that such possession was not authorized by law is of course present because his possession of the shabu is illegal itself and is not authorized by law. And that the accused freely and consciously possessed the said drug is present because Banares freely and consciously possessed plastic sachets containing shabu when he was arrested. So as a general rule, it is essential that the identity of the dangerous drug be established with moral certainty, considering that the dangerous drug itself forms an integral part of the corpus delicti of the crime. To establish the identity of the dangerous drugs with moral certainty, the prosecution must be able to account for each link of the chain of custody from the moment the drugs are seized up to their presentation in court as evidence of the crime. As part of the chain of custody procedure, the law requires the marking, physical inventory, and photography of the seized items be conducted immediately after seizure and confiscation of the same. The law further requires that the said inventory and photography be done in the presence of the accused or the person from whom the items were seized or his representative or counsel, as well as certain required witnesses, namely, if prior to the amendment of RA 9165 by RA 10640, a representative from the media and the Department of Justice, and any elected public official, or after amendment of RA 9165 by RA 10640, an elected public official and a representative of the National Prosecution Service or the media. The law requires the presence of these witnesses primarily to ensure the establishment of the claim of custody and remove any suspicion of switching, planting, or contamination of evidence. In this case, it is glaring from the records that when Banares was arrested, the buy-bust team immediately took custody of the seized plastic sachets and conducted the marking, inventory, and photography of the seized items in the presence of media representative, the Department of Justice representative, and the barangay official at the place of the arrest in conformity with the witness requirement under RA 9165. Police Officer 3 Kodia then personally delivered all the evidence seized to Forensics Chemist Police, who performed the necessary tests thereon, and which proved that the thing possessed by Banares was an illegal drug. In view of the foregoing, the courts hold that there is sufficient compliance with the chain of custody rule, and thus the integrity and evidentiary value of the corpus delicti have been properly preserved. Perforce, Banares' conviction being guilty of Section 5 and 11, Article 2 of RA 9165 must stand. So that's it for my discussion for RA 9165, the Comprehensive Dangerous Drugs Act of 2002. Thank you.